Emily Brown. I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. We're a private law firm specializing in immigration compliance, including I-9 and E-Verify. And welcome back to our Wednesday Live Compliance Corner, where we talk about the latest topics in I-9 compliance, E-Verify, and other immigration compliance matters. So today we're going to talk about paper I-9s versus electronic I-9s. When you have a paper I-9 or an electronic I-9, which does ICE prefer to audit? It's actually a trick question, just being a little bit silly. They do audit both, but the paper I-9s and the electronic I-9s do have different rules that apply to them. Before we dive in, everything that I'm sharing today is general educational information. It's not legal advice. Immigration law changes frequently, so for guidance tailored to your business or specific situation, you're going to want to consult a qualified immigration attorney. So starting out with a few core rules about paper I-9s versus electronic I-9s. The M274 manual, the Manual of Governing I-9 Procedures, gives employers three options. You can do paper I-9s and store them in their paper form, electronic I-9s where you're completing I-9s electronically and storing them electronically, or a hybrid option. I do want to start off by saying that the USCIS fillable version, PDF version of the I-9 that's available on their website, when you download that, it's a fillable PDF, so you can type into it. However, that is not considered an electronic I-9. That is treated as a paper I-9 that you're supposed to then print out and have the employer and the employee sign with a wet handwritten signature. So it's really important to understand that when I'm talking about electronic I-9s, it's a specific type of system for I-9 completion, not the one that you download from the USCIS website. If your company is downloading it from the USCIS website, it's a good practice to make sure you always have the most recent version. You want to make sure you can type in some of the fields, like you can type in the name, the date of birth, and things like that. But you want to make sure the attestation is completed properly in Section 1 by the employee, because that is going to be signed by the employee under the penalty of perjury. So it's legally enforceable. So on a paper I-9, it's really important to make sure they check that box, including the one that you download from the USCIS website, and that it's signed with a wet signature. And then that's going to be important when we discuss electronic I-9s, because there's a system in place to make sure your system has the right procedures in place to ensure compliance with the regulations for that attestation part of Section 1. So that Section 1 requirement, it's always there, whether it's a paper I-9 or electronic I-9, but what changes by format is the execution and storage, not the legal attestation itself. We're going to dive right into paper I-9s. So when you're completing a paper I-9, whether you download it from USCIS or you have a bunch of blank paper I-9s printed out already, you fill it out. You need to make sure that the information is legible, because if it's not, that could be a violation if ICE audits your company. The signatures have to be handwritten, wet signatures in ink, and you want to make sure they are dated properly. So Section 1 is signed and dated by the employee's first day of work for pay by the employee. Section 2 is completed by the employer and signed by the third business day of employment. And then if it's required for that situation, Supplement A and Supplement B as well. When it comes to storing paper I-9s, you are allowed to store them on site with the company or off site. It's up to the employer. A few best practices that I like to advise companies about when it comes to storing paper I-9s are two things. First, you want to make sure that your I-9s are stored completely separately from other employee personnel files. You should have just a designated I-9 storage area for paper I-9s. This really helps for when ICE comes to audit your company. You're only going to have 3 business days to provide all the documents that they're requesting. So you want easy access to those I-9s all in one place. You don't want to have to be searching through each personnel file to pull out their I-9 record. Second, the thing that I like to advise companies is that when you're storing your I-9s in a paper version, they're in a locked space, so a locked file cabinet or a locked office. ICE could come to your business to hand deliver a notice of inspection, or maybe even just a regular worksite enforcement action, not necessarily related to the I-9 process. If ICE comes to your business, they do have the authority to go into the public spaces of your business. So if you're a restaurant, they can enter the dining room, any lobby or waiting room, anywhere where the public is generally allowed to go in your business. If ICE comes to your business, they do not have the authority to enter private spaces without a warrant signed by a judge. So when it comes to I-9 records, it's highly recommended to keep them in a locked space so that if ICE comes, they're not publicly accessible. They can't just walk in and get them. They're going to need a warrant signed by a judge if they're not going through the normal notice of inspection procedures. Normally when it's a notice of inspection, they might ask for them right away, but the best practice is to say no and to take that full 3 business day window to prepare all of your records and make sure you have everything ready for the I-9 inspection. When it comes to correcting a paper I-9, really simple. You're just going to draw a line right through the incorrect information, write the correct information on top, and then the person making the correction, if it's the employee in section 1 or the employer in section 2, they write their initial and the date that the correction was made. There are some risks to doing your I-9s in a paper format and storing them in a paper format. There could be physical loss from fire, damage. They could get misfiled and lost. Like I said earlier, illegible handwriting could be technical violations. And then offsite storage, if that is something the company decides to do, that can slow down the process of gathering documents together if you're audited by ICE during that 3 business day window. When it comes to electronic I-9s, there are some different procedures and requirements for your electronic system. So for the paper I-9s, it's a wet signature. For the electronic I-9s, there are very strict requirements that the electronic system must have to make sure that electronic signature is valid and sufficient under the I-9 regulations. So I'm going to go through these one by one. First, your electronic system needs to let the employee know that they acknowledge that they read the attestation. So on the paper I-9, they check the box and they sign it, but you need to make sure that your electronic system is giving them that extra question of like, do you attest under the penalty of perjury that you are one of these categories, whether U.S. citizen, green card holder, or a person authorized to work in the U.S.? The system needs to make sure that it's giving the employee the opportunity to acknowledge that they read the attestation, because again, it's signed under the penalty of perjury. Second, the signature attaches to the completed form. It's not just held somewhere in the I-9 software universe. It's going to attach to the form. It's affixed to the form at the time of the transaction, so it's within that time frame for I-9 completion. The system preserves a record verifying the signer's identity. So the system needs to have a procedure or a mechanism in place to verify the person's identity. The system must provide a printed confirmation of the completion or the I-9 on request. And 6, the employer has a method to acknowledge the Section 2 attestation. So just as the employees, there's a requirement to acknowledge their attestation in Section 1, there needs to be some sort of acknowledgement for the employer when they're completing Section 2. If your electronic I-9 system misses any of these points when it comes to electronic signatures, that's going to be considered by DHS or ICE that the I-9 was not properly completed and a substantive violation. When you're completing your I-9s electronically, they're also going to be stored electronically. So there are requirements in place for storage to make sure that you are storing them properly. So your system needs to have controls ensuring integrity, accuracy, and reliability. There needs to be controls preventing unauthorized alteration, deletion, or deterioration. The system needs to have quality assurance programs with periodic checks, indexing for system retrieval, and the ability to produce legible paper copies. So that's for the storage requirements. There also are requirements in the I-9 regulations for record security program. Your company would need to have a record security program that gives access to the system that the access is limited only to authorized personnel, that the security program has a backup and recovery plan, that there is training for anyone with access to the system, and that really importantly, there's an audit trail logging every action. So the audit trail needs to have the date, the name of the user who's gone into that I-9 record, and a summary of what action was taken when they went to that I-9 record. There's also a business process documentation requirement for electronic I-9s. So your company is required to have a written description of the I-9 electronic system being used and the procedures, a description of the indexing system, and documentation establishing authenticity and integrity. There is also the option for companies to build their own electronic I-9 system, but there's also specific regulations for that as well. You need to make sure the I-9 system Doesn't change the name, content, sequencing, or instructions of the Form I-9. It cannot add elements or language, and it can't restrict government access. When it comes to correcting electronic I-9s, it's essentially the same substantive process as a paper I-9, but the audit trail is going to reflect the correction. So it's going to tell you the correction that was made, who made it, and the date of when that correction was made and what the correction was. If you're using an I-9 system right now and you want to switch, that is permitted. I do just recommend as best practices that for any of the documented procedures you had for the first system, you still keep that. If you have any records that happen to be lingering between both, to just ensure compliance if there was ever going to be an audit down the line. Now, for electronic I-9s, there are some specific risks if that's the way that you're storing and completing your I-9s. Any missing e-signature criterion that I mentioned before is an improperly completed I-9 as a substantive error. If there's no audit trail, that's a quality assurance failure. If there's inadequate security, that's a violation if the records are altered or lost ultimately. Vendor systems that restrict government access or alter the form content are not compliant. And if there's no written business process documentation, you can't establish the authenticity at inspection if ICE were to come to your business. The next option now for completing I-9s is the hybrid option, where potentially you're completing your I-9s in a paper form, but then storing them electronically. And this is a way that a lot of small and mid-sized companies do it to, reserve. They don't have to keep the paper I-9s around, but they're completing them on paper. So what is allowed is that you can complete the paper I-9s, again, with the wet signatures required, making sure all the appropriate attestations are completed. Then to convert it into a electronically stored I-9, you scan and upload the original plus any corrections or updates that may have been made. And you can only destroy the paper I-9 then after it's securely stored. But here's what most employers miss if they're doing this process. Once you scan, the full electronic storage framework applies. So all of the safeguards that were in place that are required to be in place for electronically stored I-9s, they now are triggered because even though it was a paper I-9 at completion, it's now turned into an electronically stored I-9. So that means your system is required to have access controls, audit trails, backup, training, indexing, legibility, and written procedures. And there's also a liability trap because once the paper I-9 is destroyed, lost, or there's potentially a corrupted electronic file, the I-9 is gone, and that's a violation if you knew or should have known that that loss was possible. One common mistake I do see when doing it this way, where you have a paper I-9 that's then stored electronically, just scanning the I-9s into a shared drive with no audit trail or no access controls, no documented procedures, that is not going to be compliant under the I-9 regulations, regardless of whether it's just on the computer. When it's electronically stored, there are very specific safeguards that must be in place. Now, a few rules that apply to both electronically completed I-9s and paper I-9s. If ICE does issue a notice of inspection to your company, it's going to be the same whether you have a paper or an electronic I-9. You have 3 business days usually to respond. The paper I-9 must produce the specific forms requested in some cases, but for the electronic or a hybrid situation, sometimes the notice of inspection may also request that you provide hardware and software information, personnel, audit trails, and if requested, any electronic summary of the spreadsheets of all of the fields. So some real-world takeaways here. Electronic is a compliance upgrade because there are extra procedures in place to help you sometimes. It could be that the electronic system is helping you keep track of re-verification dates or retention periods, but you need to make sure that the system meets every standard. Otherwise, it's going to be a liability multiplier. And I also caution employers when you're using electronic software systems, so some of the commercial systems that are out there, the commercial vendors, some of them have different tiers and different plans that have different functionalities for I-9 compliance. So you're going to want to check with your vendor to make sure that the plan that you're currently on does ensure compliance with all the I-9 procedures related to electronic completion and electronic storage of your I-9s. Hybrid is often the smartest move when it comes to small and mid-sized employers, but only if the electronic storage size is actually compliant. You can't just save them into a file on your computer. As I mentioned, the 3-day business day response time for a notice of inspection is going to be the same for paper or electronic I-9s. And when it comes down to it, if you're using an electronic system, it's going to be you, your company, not your vendor or your I-9 compliance system that's liable for the system defects. So vendor due diligence is critical. It's not optional, because at the end of the day, if there's any errors for not using a correct I-9 software or not using it properly, the company's going to be the one that's liable. So here's how that you can act on everything that you've just learned. If you're not sure where your system stands, whether it's paper, electronic, or hybrid, and to understand what of the I-9 procedures or policies apply to your process, you can start with our compliance assessment. It's a 60-minute attorney consultation with a written risk report and a prioritized action plan. It's going to tell you exactly what you need to do. If you already know that you're going to need ongoing protection, we are launching Immigration Suite, which is our monthly I-9 legal subscription. You're going to get direct attorney access, I-9 review during your onboarding, E-Verify support, and annual training. And right now we have our founding member pricing starting at just $297 a month, depending on business size, with no surprise invoices. Also, as a member of Immigration Suite, you're going to receive 15% off of our other flat fee legal services, and that includes the compliance assessment. So if that's something you're interested in, since our founding member pricing closes right now on April 30th, and it's subject to increase after that, we do have a wait list that you can sign up for. And by signing up for the wait list, you can claim that 15% discount on the compliance assessment if that's where you want to start. So I'm going to drop a comment with the link to the wait list if that's something that you're interested in doing. But again, my name is Emily. I'm really enjoying these Wednesday lives. Feel free to DM me or send me some kind of email or correspondence if you are interested in, there's a topic about I-9 and E-Verify compliance that you're really interested in, so I can include it in an upcoming week. But I can't wait to see you again, same time, same place, for your Compliance Corner with Elevate Justice, U.S. Immigration Law. Have a great week, everybody.